One of the questions I get asked constantly is about non-refundable deposits. As attorneys, we know that these are called the liquidated damages clauses, but they're going to call you non-refundable deposits. They're going to say non-refundable deposits, retainers, deposits, and you're going to need to know what they're talking about when they ask you that. We know as attorneys that they are meant to compensate the injured party in a contract and not to act as a penalty. However, a lot of times you're going to need to explain that to those vendors that when a contract is canceled, you don't get to keep all the money just because your client canceled. For that reason, one flat fee is usually not going to work. A lot of vendor contracts I see actually are 50-50 payment schedules. So there's 50% down at the signing of the contract, and that will work as their non-refundable deposit, and then 50% due either 10 days before the wedding or the day of the wedding or the event. And legally, if you're trying to draft it so that a judge will look at it favorably, you're going to want to do more of a sliding scale. An example of a fee schedule that I've drafted is on the screen now. I usually have a non-refundable reservation fee, and I give them the date and the amount, and set out that this is the non-refundable reservation fee. This is the fee that you give us for booking this event. We're not going to book this event and save this date until you pay us this amount of money. And then the first payment is also usually due upon signing, and I give them the date and the amount there. I've tried to break this down to make it as easy as possible for everyone to see and everyone to be on the same page. But I've also given my clients the ability to terminate the contract if their clients don't pay them on the date, because a lot of times you'll get clients who their clients make the first payment, or they make the first couple payments and then they kind of fall off the face of the planet, and you don't know if you're supposed to be saving that date or if they're supposed to be continuing to work. So you want to make sure that they can get out of that at any given point. One of the things that I also do is make sure that all of these payments are non-refundable upon receipt, and that they compensate. It specifies that this amount of money up to this point compensates me for the work that I have done up until this point. Your wedding vendor contracts are going to often be, you're going to be drafting a contract that's going to span a year and a half, a year, 2 years, sometimes 3 years if it's for an extremely popular event venue or for an extremely popular planner. So you're going to want to make sure all of these fees are set out by the date to the T, and so there's no kind of room for wiggle room, and you're going to make sure that your client is compensated up to that point. Again, a lot of times there's overage fees that happen on the day of the wedding. We'll talk about how to address those a little bit later as well, and how to modify the contract on the day of the wedding for whatever sorts of issues or problems may come up. But those are going to be due after the wedding occurs. So make sure that the client knows that that can happen and how to prepare for that. As lawyers know, the fine print can be as important as those main terms. The boilerplate is very important. Like I said before, we want to keep that as condensed as possible and as friendly as possible, but you still want to make sure you cover all those bases. Make sure your clients are protected. One of the issues that I constantly evaluate when I'm drafting wedding and event vendor clients is the mediation clause. A lot of standard contracts have that the parties to the contract will go to mediation if there's any sort of dispute. However, mediation can be very expensive, and if you're working with a smaller vendor or a vendor maybe their contracts are only a couple $1,000s per contract, it might be a better option to give them the choice to go to small claims court and not require a mediation. For example, if you have a small-time florist and they are doing bouquets and boutonnieres, and that's it for the wedding, and their contract is $3,500. If they have a dispute over their contract and their contract says in it that they're going to go to mediation, they could be spending that much or more on a mediation just on fees alone. Whereas if you go to small claims court and it's, an under $5,000 small claims court, and they go and they represent themselves and they just bring the contract and they tell the judge, this is how much was owed me, this is how much was not paid to me, it's going to be a lot less expensive for them. So that's something you're going to want to keep in mind based on the type of vendor you're working with and after you get to know the types of contracts and the types of clients that they have. If you have a florist who is charging $25,000, $50,000 a contract, maybe you are going to want to have that mediation clause in there. But it's going to depend on that client evaluation. So that's one of the reasons you really need to get to know your clients through their website, through their social media, through whatever avenues you can. Have them bring in some contracts that they've done. Ask them how much their contracts usually run and the types of clients that they're working with. And it's just another reason that you need to spend some time with your clients. We're very lucky in the wedding and event industry that everything our clients do is usually splashed all over social media, and I can go to Instagram and pull up all of my clients right now that I work with. So you don't have to do a ton of work to really get a good feel for what your clients need. Force majeure clauses are very important for event vendors, just because a lot of times you're dealing with events that are outside or events that have some sort of outdoor component, or if you are a caterer or a florist, you deal with potential shortages of your product. So make sure those force majeure clauses specify exactly what is going to constitute a force majeure event. And if you're an outdoor vendor, certainly a rainstorm isn't going to cancel the bride or groom's contract with you. You're going to need to specify what that actually means. And I'm going to touch on that a little bit more as we go forward, but just thought I would mention it here now as well. One of the issues that you deal with very frequently when you're working with wedding and event vendors is that they are constantly having to change and modify and deal with the sky falling during their events. There are always going to be additions and subtractions to contracts as they are working. They're always going to need to be able to figure out how to address certain issues. As I'm sure anyone who's ever been to an event or has planned an event knows, a lot goes on behind the scenes that people don't realize. So how does this work when you have most contracts that say modifications must be in writing and oral modifications are not binding? For a good reason. I'm not suggesting you take those clauses out by any means. I'm suggesting those stay in, but you find a way to work around it. And one of the ways that you can work around that is by using technology. Your wedding and event vendors are always going to have their phones on them. They might have an iPad. They might have whatever form of technology that they carry around to get in contact with their team, their brides, their grooms, whoever. So I have recommended 2 useful apps for modifying contracts on the run. One of those apps is Shake, and that's available on both Android and iOS, and Contract Maker Pro, which is available on iOS only. And what these apps are going to do is they're going to allow your vendor to, you or your vendor to write a very, very quick modification to a contract and have it signed by either a finger or some sort of stylus device at the touch of a button. This is very important, like I stated before, because I have had vendors have to modify their contracts and ended up not getting paid before because the person who was responsible for paying them said, "No, I never told you to do that. We never agreed." So when you have these apps at hand, make sure your vendors know that they need to get the names of both parties, what the modification is, and the signatures of both. An example of this would be, I had a planner who was in charge of making sure everything was getting off to a good start during the wedding day, and someone had forgotten to order lunch for the bridal party. And a cranky bridal party is never good. So she quickly ran out and bought $600, $700, I think, worth of sandwiches and chips and drinks and things like that. Which, as a wedding planner, that is your job. Your job is to make everyone happy and make things go smoothly and pick up the pieces. She didn't have it in writing and had to just kind of hope and pray that they were going to reimburse her for that. And a way that she could have had better peace of mind was if she had on her phone a little app that said, "This is my we are modifying the contract of this day to say they are adding a certain amount of money for X number of sandwiches, and I agree to pay the planner." And the names of those apps, again, for anyone who needs to know, I just got a question, are Shake, which is on Android and iOS, and then Contract Maker Pro. And again, that's iOS only. So those are just little tools that are good to have in your back pocket and good to make sure that your clients know are available to them so everything goes smoothly.